Hello, welcome back to the Law Review. This is Jacob Ayler of the Law Office of Riley and Ayler PC. I hope everybody's having a good week, a good month. Hope everybody had a good 4th of July celebration. I know I did. Trying to beat the heat a little bit these days. Today I want to talk about a topic that has been coming up a lot. I'm in my late 20s and I have a lot of classmates from high school, college that reach out to me for estate planning things. And one big trend that I'm seeing is the need for people to establish standby guardianships. For those of you that don't know, the law allows you to designate who would care for your kids or your children in the event that you were to pass away before they turn 18. Naturally, this is a request I get for people that are in their 20s, 30s, 40s that still have kids that live at home, because most of my clients that are older, in their 60s or 70s, their children have been out of the home for some time. In 2011, the Indiana State Legislature passed a law, and it's actually Indiana Code 29337 if you want to give it a read. But essentially what it does is it allows you to designate who you would like to be named as a temporary guardian of your children until you can get in front of a court to make it permanent. And what the statute does is it allows you to pick somebody to take care of your kids, and it makes it effective for 90 days until you can get in front of a judge who would then, listen to your background and make sure that the person is appropriate before making that person a permanent guardian. This is a big concern for a lot of people, because if you're 30 and you've got 2 or 3 kids that are just very, very small, whoever you pick to be their guardian is going to be the person who would raise them if something were to happen to you or to happen to your spouse. The terrible example I give is if you have 2 people that are killed in a car accident and both parents are lost, and they have kids that are 3 or 4 years old, you're going to have somebody to raise them, pay for their needs, take care of their stuff, sign those permission slips, take them to those doctor's appointments, and overall just make sure that they turn out to be the best adult that they can under that guardian's care. And so what we can do is we can put together a document that specifies who you would like to have step into that role. And that's important for a few reasons. Everybody has family members that they love, but for one reason or another, they may not want them raising their children. Perhaps you have a sibling that just is irresponsible, or maybe has an addiction problem, or just lives on the other side of the country away from the rest of your family. That may be a person that you would want to list in your document as somebody that you would not want to be the guardian of your children. While at the same time, you may have specific conditions like naming a brother and sister-in-law, but if they're divorced, then just the brother-in-law, because you may not want your children being raised by your ex-in-law. And so that this document can be prepared in the form of a will, within the will, or you can do this as a separate document itself. And this is why I still think it's so important for younger people in their 20s, 30s, 40s to still talk to an attorney about getting a basic estate plan done. The big pushback that I get from people my age is, hey, I don't need an estate plan because I'm young, I don't have a lot of property yet, and most people don't think that anything's going to happen to them in the near future when they're 30 years old. But the facts is that you do need an estate plan because people that are under the age of 40 die all the time in unexpected illnesses, car accidents, freak accidents, and B, if you have children, you need to have something set up in place for them to make sure that the life insurance money that you have set aside for them, or any money you have that they would inherit, is going to be managed by somebody who's responsible, who has the same moral compass that you do, that is going to fulfill your wishes. And so you can solidify those concerns by putting together documents such as a standby guardian to make sure that that happens. I will say it's interesting looking at how the law is written now in Indiana, because the standby guardianship provision has only been around since 2011. So in legal terms, that's fairly new. And so I'm waiting to see what the case law says coming down from some of these things that may be contested. For instance, people naming guardians when another parent still lives. For instance, if you have an ex-spouse who has visitation with the children, if something happens to you, they're going to be the one that gets custody. So if you name a friend of yours or a sibling of yours to be a guardian of your children, if you have an ex-spouse who has visitation with the children, barring very extravagant circumstances, that person is going to end up getting custody, and they're going to end up raising your children. So there's a lot of factors that you want to consider, and talking to an attorney to walk through those steps is the best way to look at it. If you're watching this video and you want to dig into this issue a little deeper, feel free to shoot me an email, jacob@michaelriley.lawyer, or give me a call, 219-866-3435. Be happy to walk you through the steps and what we could do to try to make this better for you. Thanks. Until next time. See ya.